Welcome to the Colorado Trial Lawyer Connection, where Colorado trial lawyers share insights from their latest cases. The pursuit of justice starts now. Welcome back, everyone. Keith Fuicelli here for another episode of the Colorado Trial Lawyer Connection podcast. This time we have sort of a different and absolutely fascinating and tragic case involving a jail suicide. And there are so many legal aspects to this case that I know very little about. So I, for one, am excited to increase my education as it relates to these types of civil rights cases. And I know that this was an amazing verdict, what I believe to be a very deserving mother. So with that introduction, excited to have Sean Dormer back for his third appearance on the Colorado Trial Lawyer Connection podcast, which is a record and means that Sean is out there in the arena time again, crushing verdicts. So Sean, with that, welcome back again. And Spencer Bryan, happy to have you on the podcast for the first time. Tell us a little bit about yourself and how it is you came into the trial world.
Yeah, thanks, Keith. It's great to be here. I kind of came into the trial world, I think, reluctantly. I kind of resisted being an attorney, I think, even from back in undergrad, but nature has a way. And I just, I've had this kind of anti-authority streak, my whole life, and it just seemed like this kind of natural fit. And so went to law school, got out, and started actually doing defense side prison litigation, jail and prison litigation in Oklahoma.
Wow.
So it was, like actually in the other side's camp for about, 5 or 6 years, represented wardens, jailers, county commissioners, police officers, all over the state of Oklahoma. And it was actually a private prison company that I was actually doing work for, which had the contract for the Tulsa County Jail at the time, which is a 1,600 bed pretrial jail facility.
Okay.
And so that experience, I'm doing every type of litigation that was coming out of that facility. So you can imagine it would, run the gamut from, assault and battery to, suicides, inmate on inmate violence, things like that. And then eventually the private prison company lost its contract. And so I had this kind of skill set and not really a good place to apply it. And eventually I was able to, I started getting calls from other plaintiffs' attorneys asking about, hey, what do you think about this case? What do you think about this case? And eventually I just thought, well, I just need to start working some of these cases on the other side. And I ended up, loving being on the plaintiff side of it so much more. And it was so much more rewarding. It was really what I wanted to do eventually, but I felt like I didn't have any experience to do it. So after I had, gotten my feet wet a little bit, I started taking these cases, and we've been doing it, me and my partner, since 2011 now.
2011. So
Yeah.
quite a while. Were you in Oklahoma at that time? How'd you come to Colorado?
Yeah. So actually, it's kind of a funny story. My wife is actually from Texas, and we met in Oklahoma, and she wanted to move back to Texas, and I was, that wasn't going to happen.
Okay.
So because a lot of what I did was federal law, and being in the 10th Circuit, I didn't, old dog new tricks, not really interested in moving to the 5th Circuit. So Denver was a happy compromise. And we moved up here in 2017, and I've really enjoyed that decision, and I've really enjoyed participating in the bar here with other attorneys. It's really been a great experience.
And so your law partner is still in Oklahoma?
Mm-hmm. Yeah, he's still in Oklahoma, and I still go back. And I was actually just flew back in last night. Was just out there yesterday.
Okay. Your firm practices primarily civil rights litigation. Is there more other areas that you all specialize in?
Yeah, we mostly do civil rights litigation, which is a pretty big umbrella, but mostly specializing in jail and prison litigation. And we also do police misconduct, excessive force on the street type of cases also.
Okay. Well, let's talk then a little bit about this case. So I wanted to jump right into the facts of this case because I do know that it's a fascinating case. But before we get into the real heart of it, I am very curious about the screening process. So, Sean, I think this question goes to you because my understanding is that your office sort of gets a call involving a jail suicide. Tell us a little bit about the process that you and your firm go through when a somewhat unusual case comes in, and then tell us what happened here.
When I have an unusual case come in, I usually try to kind of learn about it, and I come at it from the standpoint of just looking at damages first. And if something really terrible happened, I usually try a lot harder to make sure that I uncover every stone. And that's not to say that we, don't do research ever on cases where people thankfully aren't, gone or catastrophically injured. But I do start there when it's a serious injury case. I also, by the time we did this one, my law partner actually looked at it and had initially wanted to, or even maybe had turned Sarah down. But I had recently been doing some pro bono appointments through the federal court here, and they had all been jail or prison cases. And I had this, relatively simple, very low damages. I thought it was a valid case. It was, there was some comedy involved. I think our client would agree. And it was something that I had talked to Spencer about as kind of, a mentoring thing in this area since he had done a bunch of this work. So we were getting lunch and talking about that case, and I brought up this one, and he sort of immediately realized it was a good case. And from there, I have I've sort of gotten more understanding of the law from in this area through this case, and so now I think I'm probably a little better at evaluating them. And we do that through a lot of open records requests. A lot of these documents are actually required to be provided, so you can do a lot of investigation that way and sort of decide before you file. But that's getting a little ahead of ourselves. I think Spencer should probably speak to the some of the criteria he uses too, because I think he's got a lot more experience in this area. So
Well, and Spencer, tell us about the conversation with Sean. What did Sean tell you, and what piqued your interest about this case? And this, just so our listeners are aware, because I'm not sure if we've covered it before, but this was a jail suicide case. And so, as you answer that question about what piqued your interest, can you help me learn what duties does a prison setting owe to inmates?
Sure. So the jail suicide contexts are there. You see, suicide is the leading cause of death inside jails. So it's not necessarily uncommon to see a suicide case. The problem is the factors that you have to tick off to be able to get one to trial just almost never align.
Hmm.
So when Sean was talking to me about this one, and he mentioned the fact that Jackson had actually communicated his intent to commit suicide to jail staff, and then nothing was done in response to that, all these red flags started to go off in my head because that's just one thing that doesn't happen. I mean, one, I guess, positive aspect of our criminal justice system, I suppose, is that it is a rare occasion when somebody admits to being suicidal, expressly admitting to being suicidal, and then nothing is done.
Hmm.
I mean, typically there's something that's done, and it may be inadequate, it may not be enough, it may be misguided, but typically there's something that's done. In this situation, it appeared that there was, nothing. That this Jackson had communicated that he was in, distress, and they just ignored him. And seeing those factors lining up, it just made me think there's more to this. We need to look into this a little bit further. And kind of like what Sean was alluding to, one of the benefits of dealing with a public entity is that you can get records,
Hmm.
pre-suit discovery. And it's also one of the reasons why I think things like Cora are important and need to be strengthened, through the legislature, because that's how we get transparency in these types of cases. And it helps attorneys figure out, is this a case? Is it not a case? Is this something that needs to be looked into? And having that, kind of second set of eyes, unfortunately, we don't have an independent mechanism that's really going to, review these cases in Colorado. And so it's kind of left to the private bar to do it for the public.
So, how did the actual documentation of his intent or desire to want to harm himself, how is it documented in the records? And is that something sometimes people would, omit, or do they have an obligation, sort of industry standard, you need to document that? So tell us a little bit more about the documentation you found and how you found it.
Yeah, so we submitted a CORA request, or Colorado Open Records Act request, for the investigation file and for the surveillance footage. And I believe we knew that one of the jailers involved had been charged with a crime for falsely completing his cell check logs. And so we requested the information arising from that too. And what we ended up getting from the county attorney, and it was sort of outside counsel county attorney, who sent us a big collection of things, was some phone call recordings that they preserved. We got the surveillance footage, and we got a number of these reports, and the reports were actually pretty inconsistent with each other about who reported what he said, what they said and when. And then the surveillance footage, on the other hand, was pretty clear because there was a microphone in the jail cell where Jackson was put. And so when you look at the surveillance footage, it became really clear he began banging his head on the wall in the cell, on this sort of metal dividing wall, and it reverberates through the jail. And then they come running in. It only takes them about 10 seconds to get in there, and they ask him what he's doing. And he says, "I'm trying to kill myself right now." And that's a direct quote. You
Oh,
can hear it. And then the jail captain has no way of denying that he heard it, because he repeats, "You're trying to kill yourself right now."
oh my
And
gosh.
so it's pretty stark. The excuses were interesting. Well, he was standing there in the middle of the jail cell and he wasn't doing anything, so I didn't think that he was serious. That was kind of an interesting excuse, but that was how we got the data. And so I think, the objective evidence is really important. I think Spencer should probably speak to some of the issues of how common it is that we'll get inconsistencies in the reporting, though, because I think that's an important issue. And I think it's, I want him to cover it. I'm not going to steal his thunder, but it's a problem. So
Well, and before we jump into that, where did this occur?
this happened in Saguache County, Colorado, and it's the town of Saguache is the county seat. It's down in the San Luis Valley, and
Hmm.
it's the valley it's narrow at the very northern end, and then it opens up after several miles of kind of this hemmed in area. And right where it opens up and the road kind of curves west, if you're coming from the north, is where Saguache is, and it's sort of right at the northern foothills.
Got it. So before we talk about inconsistent statements, how long after your client said that he was going to harm himself and that he was trying to kill himself did he kill himself?
It was probably, and I'm blanking on the exact minutes, and I had that down at one point, but it was, I believe it was within around 30 minutes,
Oh my gosh.
to an hour when he started to hang, put some weight at least in the ligature and the noose. And then, it was really hotly disputed when he actually passed away, because he had his hand in the noose for a long time. He was supporting himself with his legs for a long time, leaning into the bunks for a long time. There's a lot of evidence that this may have been a cry for help, that he wasn't sure he really was going to go through with it. So that was a big deal in the case. And so it's possible he was still alive, well into the evening, and his body unfortunately was not found until 7 a.m. the next morning.
Wow. And I guess that brings up another question that I had, and maybe Spencer, you can talk about this. One of the jailers did I hear that he was charged with falsifying his logs? Is that right?
Right. Yeah. And that's another big factor in evaluating cases like this is when you see, and you see it in malpractice cases also, where you see phantom site checks, things like that. And anytime you have somebody that's engaged in phantom site checks, you obviously, again, red flags are going up, because that's not going to be the first time it happened. So surely this is something else is going on. And I think the other factor that really caught my attention when I was talking to Sean was the fact that nobody found him for 8 hours.
Right.
And that's, I mean, there should be, when industry standard would be, check on somebody at least every hour to check on their welfare. And the fact that he wasn't found, and there were phantom site checks saying that he was okay, really kind of ratchets up the sting factor.
And to be clear,
Would,
that industry
yeah.
standard is if someone is not suicidal, doesn't have a
Wow.
risk of suicide. So when there's a risk of suicide, the industry standard is properly, and is becoming in most places, at least, if not already is, constant supervision.
Yeah, through video means or otherwise, you have eyes on the person at
Yeah.
all times when they have demonstrated that intent. So, was there evidence that had the jailer who falsified his logs done what he said he would have done, that your client would have lived?
That would have been tough. If it was just the standard hourly site checks, it's possible. It was at the same time impossible to prove when exactly he passed away. The bigger thing, though, was that as soon as Jackson reported these symptoms, he should have been put on a suicide watch that would have involved taking the curtain and any other fabrics out of his cell, putting him in a suit, a special, they call it a suicide suit or a turtle suit, that prevents someone from, doing various things that can hurt themselves. Um, Increased checks from there, calling mental health. But the two big ones would be the suit and taking away, essentially taking away weapons. That the things that someone can use to hurt themselves if they're not in their right mind, if they're not safe.
So, Spencer, talk to us a little bit about this issue of inconsistent statements, and when you're trying to sort of determine what the facts are in a case like this, the challenges you face.
Yeah, it can be difficult, because there's always this kind of self-interested motivation going on, with jail staff, and you always have to look at, like, you know, who's really motivated to do what and say what, in these circumstances, and that's why video really is kind of a great equalizer, because it doesn't leave any question as to what's going on. But
Mm-hmm.
even with video, you end up still getting into disputes about what actually was said or what was understood, and things like that. And then that video also helps to identify what would be conflicting statements in different reports. So for example, in this particular case, we have statements by the arresting deputy that are contained within the investigator's report, that she later testifies that I never said these things.
Hmm.
And just completely disputes the fact that this investigator, that she ever said these things to an investigator, which also creates additional questions. But then you can also look on the video and you can see that things that she is saying aren't necessarily true either. She's saying, well, I didn't even go back to the jail the next day, and then here's video of her at the jail. So it creates sometimes more questions than it answers, at the outset. And so it's kind of like an onion. You start peeling back these different layers, and it's like, well, what's going to be behind this next door? And it's always kind of a mystery. And then there's all these other avenues of information that you start looking at, and you're thinking, okay, and the case just starts to kind of all these tentacles start growing out from there, and then you got to reel it back in for trial.
So, Spencer, please help me understand what duties the jail owes or the government owes in a situation like this? Because I mean, I've never handled this type of case, and so I would have no idea. What do the jury instructions look like for a case like this in terms of duty?
Yeah, good question. And it's a really really difficult standard to meet. It's basically called deliberate indifference,
Hmm.
and the standard is essentially that whoever it is that you're targeting, well, first of all, you're the decedent in this particular case, Jackson, has to suffer from what we call an objectively serious medical condition, and it's universally recognized essentially that suicide is obviously a substantial or medical condition that will put you at substantial risk of harm or death. So that's really not where the argument is. It's typically on the subjective prong of deliberate indifference, and that's when you have to prove that whoever has the duty or whoever has the responsibility towards this individual understood it, saw it, and appreciated it, and drew the inference that yes, there is some issue here. That if I don't do something, some bad thing will happen, and then just essentially walk away and not do anything. And one of the issues that you get into in these types of cases is you get defense counsel who will want to get up and argue that, yeah, sure, my client was negligent. My client was negligent all day long, but that's not enough. You've got to prove that my client was essentially reckless or
Hmm.
almost criminally reckless to be able to prove liability. And so it's this weird situation where you've got defense counsel that are embracing the negligence standard and saying, my client was only negligent.
Wow. And talk to me a little bit about qualified immunities and immunities that come into play in a case like this that you got to overcome.
Yeah. So anytime you're suing under 1983, you've got to consider what you're going to do with qualified immunity. Because if you're suing an individual, that's what you're going to have to tackle. Now, it's not a problem if you're suing the entity, if you're suing the agency itself. Like you don't have to deal with qualified immunity in that regard. But in this case, we thought this was a good candidate for a to defeat qualified immunity. And you have to basically show two things. You have to show that there's a violation of a constitutional right, and then you have to show that it's clearly established, and that is defined as materially similar facts that have been decided in a published decision by the United States Supreme Court or by the Tenth Circuit. And the problem over time, and one of the big criticisms of qualified immunity, is the fact that judges aren't clearly establishing the law. They'll just decide that it's not clearly established and then just move on from there. And so it results in this stagnation
Hmm.
where there's no advancement of constitutional law. And that was one of the issues that we ran up against in this case. And I remember while we were briefing this, and Sean wrote an amazing brief on it, on why qualified immunity is not textually supported in the U.S. code, and it was great, and now I use it in other cases because it was so well done. But I've yet Sean, one of these days I'm going to get a judge sign off on that. Hopefully,
We got it. We got to win it someday.
I know.
I mean, it's interesting. Like just a trivia point on that. Congress originally passed the law that became Section 1983 with language that said, and I'm going to reverse the order in some way. I know I will, so don't quote me on this. But notwithstanding any state law, statutes, etc., it gives a long list, or custom, and the I believe it was the word custom or usage. I think it's custom or usage is essentially synonymous with common law, and the idea of qualified immunity arose from common law immunities, and so Congress meant to and expressly barred judges from applying this immunity to defendants in these cases. But when around the same time the revised statutes, which is a precursor to the U.S. Code, were being put together, and all these acts were being sort of categorized, and they split this act and put it in two different places and forgot to put that key language in either place. And so now it is not part of the code. Now, if that happened in the U.S. Code, there would be a very clear remedy for it, provided by one of the very early, kind of earliest in the U.S. Code provisions. But the revised statutes were passed as what we call, I think it's primary law. So they didn't have that, what if we get it wrong standard. And so it's an open question. It's an interesting question, and I will share that brief far and wide if anyone comes across. If anyone claims qualified immunity, fight it tooth and nail and take it all the way up, because it's morally unjust. It's also contrary to congressional intent.
So, speaking of taking it up, I know that you all ended up in the 10th Circuit, sort of on interlock appeal. Talk to us a little bit about the procedural posture of how that appeal went to the 10th Circuit before you even got to trial.
Spencer, this one's yours, I think.
So
I've been
yeah,
waxing poetic about legal issues for too long.
no, I enjoy you talking about qualified immunity. It warms my heart.
Yeah,
Um,
yeah. The
so
fiery
yes,
rage.
so it's when the district court denied their qualified immunity motion. Of course, you're happy or you're excited about it, but at the same time, you also know that all it really means is it's about to tick off, a much bigger fight over at the circuit. And so it's both a blessing and a burden, but it's a necessary evil, I guess, that you have to endure in these types of cases. And so when they, had the right to file their interlocutory appeal, and they did, and that's when we were discussing, because of the difficulties with the clearly established law prong, particularly in the 10th Circuit, and not having any case that you can point to and saying, aha, there it is, that's the law that establishes, or that's the case that establishes the law. We thought this was a really good, because of the egregious facts in this case. I mean, you're talking about somebody who's directly articulating suicidal intent. So it's not like you're having to infer it from prior behavior or somebody came in depressed or anything like that. It's an explicit statement of suicidal intent. And then a response of nothing, doing absolutely nothing, not putting them on suicide watch, not putting them on increased checks. And in fact, there actually was.
They're lying about what they're doing.
There was actually, in one of the things, because even not doing something is sometimes not enough. You have to show still that they didn't do something despite knowing that not doing something was going to cause a problem. And so one of the interesting facts in this case was that as the jail administrator was leaving the cell, he turned to the arresting deputy and said, "We need to do something more for him," which
You got that
shows.
on video? The video?
Yeah, it was caught on the video, and then the audio kind of trailed off, and so we kind of had to piece it together a little bit by getting the jail administrator to admit that that's what he said, but he didn't dispute it. And then shortly after that, there's actually a call that was placed to mental health, and that is consistent with their suicide watch policy. So it definitely appeared like they understood, they heard the statement, they understood it, they took actions that show that they inferred, they drew the inference that this was a problem. And after nobody answered from the mental health agency, they just continued about their business and never did anything else. And that was the evidence that both the district court and the 10th Circuit relied on to eventually deny qualified immunity to the jail administrator.
Okay, so talk to me a little bit about who you sued. Who wants to cover sort of who are the defendants in a case like this? Sean, you started this case, right? Who'd you sue?
Actually, we drafted the complaint together, and Spencer did the lion's share of the work on that. Just to be clear, but we sued. We did admittedly do a little bit more of an everyone under the sun, and we did feel strongly that we had a case against everyone we filed against. So I mentioned the jailer who allegedly falsified his logs. He was the lone jailer that night who actually had that title. We sued him. We sued the arresting deputy because there was some evidence in the. First of all, she stayed until after he tied himself to the bars, and then she was distracting the others. There was some evidence that she may have been directing activity in some way, although that didn't really come out in the record. In discovery, everyone kind of was cagey about that. We filed against the dispatcher, and dispatcher is kind of a misnomer there because she's actually got the job of dispatcher, and she also has another job serving as what we usually call control, which is the person watching the surveillance footage and sort of directing people and giving people that overall intel in a prison or a better designed correctional facility. She also would be in control of doors
Hmm.
and would remotely operate those doors, but that wasn't a thing there. And then we sued the jail captain, who was he was the real driving force behind doing nothing, as it came out in the record. In fact, left without checking on Jackson, despite the fact it only would have taken 10 seconds, and left right as he was starting to tie himself to the bars. And then we also filed against the sheriff. This was a sort of an entity liability claim on a failure to train. Uh, and then we filed against the Board of County Commissioners because in the notes for years prior to this, the sheriff had been complaining about lack of funding and how that was, inevitably going to lead to a lawsuit or an injury. At the same time, the Board of County Commissioners rebuttal was pretty credible, I think, which was, well, every time you gave us more money, we helped you, or asked us for more money, we helped you find it. And I don't know what you keep complaining about. And here we see you buying new cruisers, and there's still problems with this jail. And so there's
Wow.
some finger pointing there. But I think that covered everything. Did I cover everything, Spencer?
Yeah, I think so.
And all those parties remained in the case throughout to verdict form?
No. No. So we, on summary judgment, we lost a couple. We lost the arresting deputy because she did not have a legal constitutional duty after passing off. Now, they didn't formally sign over custody until later, but everybody agreed that she gave over custody, in fact, when they left him in the cell for the first time.
Okay.
Um, and that's that. I'm paraphrasing a lot of the order, but I think that's the strongest core of the order on that. I kind of tend to agree with it. And then with the dispatcher, we lost on summary judgment as well, and I was a little disappointed in that because I thought she had a duty, and she admitted, in fact, on the stand in this trial that she, quote, "I failed in my secondary duty that night
Hmm.
by not checking on him on the monitors." And I I think there may have been a little bit more tenuous record on her personal subjective knowledge, and that was a little more of the underpinning behind that order. But I think she admitted she had subjective knowledge, but that's a debate for an
Yeah, let me make
irrelevant
sure that I
debate
got
at this
that.
point. So,
Let me make sure I got the facts on that. So the dispatcher, she's the one that could have looked at the monitor, and this is all on
correct.
video.
Yeah.
So, and it's her job, presumably, to look at the monitor, I guess,
Right.
every so often. And the court ruled that she did not have, help me understand this, she
I,
didn't have a duty
Spencer, I
finding.
think I actually might be getting that one wrong. I was always a little confused about the basis for that one, but so maybe you remember it better than I do. Yeah.
So I think this was the classic where the court just punts and says it's not clearly established that a dispatcher has a constitutional duty to watch this monitor more frequently than she did. If
Oh,
you had a
okay.
case that said that, I would be happy to rule in your favor. But there's no case that says that on Tuesday at 10:15 p.m. that this dispatcher has to be looking at a monitor. So too bad. Um, you know, that's not enough.
Yeah, tell us a little bit about your judge. I know you were obviously in federal court. So, who was your judge, and what'd you think?
Judge Wong. Well, we actually started out with Judge Martinez, I think it was,
Yeah.
and we hadn't had much in the way of need for court intervention through the discovery process, so we didn't really engage with the judge that much. And then out of essentially nowhere, it seemed like he recused, and citing actually the misconduct of opposing counsel in a different case where the judge had referred opposing counsel to for disciplinary action, and so he believed that it would be improper for him to sit on another case with her as counsel. So we we lost what we thought was a pretty good draw, because of opposing counsel's misconduct, and thought, well, that was a pretty ingenious strategic move by them. So we ended up with Judge Wong, and she was new to the bench, and so she was collecting cases, I'm sure, from other judges at the time. And she's gonna be tough on you. She's gonna make you prove your case. She's not gonna give you much in the way of the benefit on the evidence, but she'll give you the benefit of the doubt on the inferences that you'll need. And so I was pleased with the draw, and I thought she tried a really good case. Sean would probably be a better person to
Yeah.
talk about that.
Yeah, I would say I would agree. She was a very sharp legal analyst,
Hmm.
and I very rarely. I mean, I don't think there was a single thing where I really strongly disagreed with her. I think there were some where I kind of thought, I don't know that I would have gone that way. Even rulings in our favor, but I get it.
Hmm.
But very very rarely, and the other side didn't appeal either. I think for a lot of the same reasons. I will say she got a pretty cold panel in jury selection, and she did. And I say this, I probably would have struggled with that panel as well. Had I been in her position, trying to warm them up and getting them talking, but they did not want to talk about a lot of the issues. There were a few people who opened up very well, but it was in private, and because of this, difficult issues involved: substance use disorder, addiction, suicide, very 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 difficult issues. And so she addressed these in private. I actually, in retrospect, would ask and next time, if I handle a similar case, will ask for the judge to do these as a group, unless the jurors specifically asked to, because I think that type of disclosure can really help other people open up. And I think they struggled with that in this one. It was interesting to see that.
Yeah, I was when you were kind of going over the facts of this case, I was thinking to myself, I'd be worried that a certain percent of jurors would think, well, he did this to himself.
Yeah.
So what irrespective of the legal duty that you put on us, why should
Yeah.
we, find the city negligent or the county negligent, let alone award? And what was your well, let's hit on that. What was the verdict and what was your ask? I don't know, Sean, you want to cover that?
So my ask was $75 million, and I still
Okay.
believe that. I don't see how my go-to is, I don't see how someone's private jet can be worth more than than someone's life, even
Yeah,
if they're
yeah.
at their worst point they've ever experienced in their life. Even if they're in the throes of this mental health crisis, there's a lot to say that he still, he still had hope. And I also have to recognize, especially after focus grouping this quite a bit, that I'm a wild outlier, but I asked for what I believed in, or for number that I believed in. Our
Yeah.
verdict was $4 million, which I struggle with, because I disagree with that pretty strongly. On the other hand, it's the largest one we could find in Colorado, and it's probably in the top 10 of what we could find in the country on a suicide in custody. And so it's challenging cases, and so I have mixed feelings about it.
So, sort of, I'm hearing, I mean, I definitely am seeing the challenges that a case like this has, and you have a lot of good facts in this case. And so you were maybe, am I sensing a little bit of disappointment? I mean, to some degree there. I mean, it's still
Oh,
a great, amazing result, but that's what I'm hearing. And you're,
thanks. I mean, but yeah, my friends, you included, I think, Keith, give me a hard time about always being a little disappointed. Like,
okay.
that's not entirely true. I have very much both feelings in me at the same time. I mean, I'm really proud of the result, and proud of our team, and really really pleased with the result. And it is groundbreaking, and it's important, and it moves the ball in a huge way. At least here in the 10th Circuit, and in Colorado. And that's super important, and I'm thrilled about that, and I love that. And our client's happy. And so I'm happy in a lot of those ways. And then there's that hyper competitive part of me that just thinks, well, a win, and even a clean win, is not good enough. I want an absolute crushing where the other side, you know, regrets it for the rest of eternity, and I'm never satisfied unless I get that, and I'm gonna keep doing this until I do, and maybe I never will ever be satisfied. But that's also what makes this job fun. So
Yeah,
I
yeah.
don't know, that's kind of where hopefully that explains it a little better. So
Well, Sean, I'm sure that any of our listeners that know you and your work ethic and your skill
yeah,
set know it's not if, it's when that
I
you're going to hit that ball out of the grand slam.
see.
I mean, that's amazing, amazing work. I was going to ask about sort of
Not
your,
to learn. So.
yeah. Tell us a little bit about your client, the mom. What was
Yeah.
would tell us a little bit about what it was like to be able to fight for her. I don't know, Sean. You
Yeah,
want to cover this?
yeah, she's a wonderful person. I mean, either of us could fight for this. I mean, Spencer and I have known Sarah now for over a I think over a half decade. And she's been one of my favorite clients. I know I've heard Spencer say, more or less the same. We don't pick favorites, by the way, for our other clients. But no, I mean, in reality though, it's been one of the honors of my lifetime to work for her. She's got a lot of wisdom, and she was calm and collected, and she did very, very well on cross. And I still remember a time when opposing counsel, not trial counsel, but they were the people who were replaced by the carrier, before trial, and who were handling discovery, and the lawyer who was handling her deposition asked what I felt was a pretty gross series of questions, and I'm not going to air it here publicly because it's confidential, and
Yeah.
it's a really tough thing that Sarah went through that I think was unrelated to this case. And she asked her, if she could apportion her grief between that and losing her son.
Oh my
And
gosh.
Sarah just very, very, I thought very gently but firmly, and in almost this kind of motherly way, said, I almost, I forget her words, but it kind of was this: I'm surprised you would ask that. And I don't, like kind of a little bit of that's a really difficult question to answer, and I don't even know if that's an appropriate question to ask. And I don't I I sense kind of this. It was a reversal without coming across as defensive or combative.
Hmm.
And opposing counsel sputtered and then asked if she needed a break, and I kind of laughed to myself, and I shouldn't have done this, but I couldn't help it. I turned and said, are you sure are you sure you don't need a break? We can
Oh
take a break
God.
if you want to, and
Oh my God.
it
I wouldn't
was
have been able to resist either.
I shouldn't have done that. I had to chirp at her,
Yeah.
but
Yeah.
but that was it. It was, it turned out to be pretty disarming, I think. And yeah, there was that was great. And she's just a good person. So.
Now I understand that she sort of had some real suspicions and red flags were off and did a fair amount of investigation in bringing the case to your firm. Tell us a little bit
Mhm.
about what she was able to uncover and how.
Yeah, I mean, she connected with some of Jackson's friends down in the valley who gave her, some, I'll say, vague suspicion, but just gave her the information that, look, it's really this agency is not everything. It's not someone you can take, or not a group you can take on face value.
Okay.
She also had family advise her. I mean, she was really on autopilot. I think if she would tell you herself, is she's just really struggling to get through things. Was not really planning this stuff out herself, but she had some family members who advised her to call and ask these questions about what happened. She called the jail captain, and another family member decided to just record it because, she knew Sarah wasn't really processing anything, and they recorded this phone call with the jail captain. And the phone call, he said that she was going to be the first to know about this investigation and what happened, and told her these things that were blatant out and out lies, and then never followed through on giving her the results of the investigation. So she ended up hiring us primarily to just find out what happened. And I thought, someone dies by suicide in jail, that's just not supposed to happen, and that was my belief all along. And I didn't know there was going to be a case, but I told her that. And I said, at the very least, it's free to go submit, or cheap to go submit a core request. It's not free, but it's inexpensive to submit a core request, at least for compared to the costs we're used to advancing in personal
Yeah.
injury cases. And
Yeah.
we paid the copying charge and got the data, and it was it was exactly what we feared and kind of unfortunately expected might be in the records. So a lot of it was just
But
not taking a she didn't accept I don't know. And I think that was what she needed to do to fight for her kid.
yeah, yeah. Were there any serious sort of pretrial settlement talks on the case?
Define serious, smart ass response. Sorry, but I mean, we tried
I
really
would,
hard to get them to consider paying policy limits. I still think there's a chance if we get all the post trial rulings to go our way, which we're optimistic about. I can't really comment on those at this point, but
yeah.
but if we get what we asked for, it would be above policy limits, I believe. And the defense, the highest that they ever got was a $3.5 million offer, which is
Hmm.
below what our verdict was. We also offered to let Macias, the line deputy, out for a much lower number, but they wouldn't let him out unless we would agree uh, to a high low that would be based on the verdict and would waive our right to go seek fees.
Hmm.
And that's a non-starter for us. And so they pretty well collapsed. They pretty clearly collapsed. And I think it really went back to the defense's evaluation was that his life didn't mean anything, and they were going to ask the jury for a $1 award, even if they found liability, and that's what they did. And um,
Wow. How did
I'm
that
pretty,
land? I mean, that seems like a strategic mistake. I don't know,
y-
Spencer. You
you
used to
know,
do defense work. What do you think? A strategic mistake? Award a
yeah.
dollar?
Yeah, I think by the time that we got to closing, it seemed pretty clear. I think how the evidence was coming in. I mean, clearly it was just. I mean, and I think one of the things that surprised me the most was when defense counsel in their closing argument, we didn't have much in the way of economic damages. Jackson didn't have a good employment history or earning history. So it's really all based on, what Jackson's life is worth, going forward. And I think one of the critical mistakes that they made was trying to tell this jury, who I think probably more than 50% of them had some type of close experience with suicide, either a family member or a friend or something like that,
Hmm.
or substance use too
or
is
substance
another.
abuse. Yeah. And they got up and they said, look, we know how Jackson valued his life and what he valued his life at, and because he killed himself. And
Wow.
yeah, and I just thought, I mean, that's just you're just telling, this jury that their loved one, their family member, their friend is, who is struggling with these issues is not worth anything. And I think it was relying on kind of this historical stigma that relates to suicide, in really a venue that it wasn't landing with those jurors.
Wow. I mean, that just feels offensive is the word that comes to my mind. But maybe it works. What was your jury panel like? Tell us a little bit about the folks that ended up sitting on the case.
Yeah, and I'll just say, we could have gotten a jury who agreed with exactly that stuff. I mean, we
Hmm.
saw it in focus groups, we saw it in our data study that we ran. They were the minority, which is why we tried the case, and I'm grateful for that. But people still have a lot of beliefs about suicide that I think they're not evil or mean. It's just they're protective. It's easier
Hmm.
to explain it away if you can say it's a choice. And it's easier to sometimes for people to understand it. But our jury panel included um, an an economist, a labor economist who serves as an expert witness nationally. No one we knew of. It was like employment discrimination, like union type cases. And he was a father of five. We suspect very conservative, registered libertarian. Um, and wife ran a in-home daycare. We could do some limited background, and I'm trying not to disclose specifics of who they are, but we had a couple gentlemen who worked blue collar jobs from kind of the Boulder area.
Hmm.
We had the daughter of a higher up in the police department in a rural community out in eastern Colorado.
Wow, that
or
seems was
northeastern
that
corner.
that seems is that was that did that scare you? It seems that
Yeah,
or
I mean, very much so. It's just that, the answers she gave to actual questions, we decided to trust her that she was honest. And,
mm,
a lot of what we got, there was another person from her same town who is a social studies teacher. A lot of what we got, we felt okay with on liability. And we had to kind of use our peremptories, very limited peremptories in federal, as you know, you get three,
hmm
on a civil panel. And, we had to use those on people we were much more concerned about, and we had to accept some folks we knew would be very conservative on value, on the money issues. And, it is what it is. Everyone has people have very vastly different ideas of sort of money and what money means, and that's I have no judgment about that. It's one could easily argue that doing what we do, we get an out kind of the opposite of a strange or skewed view of money. And maybe that, I tend to think it comes from, we sit and have to look at how few of our clients would actually trade what they've been through for the money they are given.
right. Yeah.
But, and how much medical care really does cost. But that's not most people's experience. And they brought theirs. So
I'm assuming I know the answer, but did your client's mom ever get an I'm sorry or any kind of anything from the county?
I don't think she did from the county or uh from the captain, but, and this is one of the most beautiful experiences I've ever had in a
Ooh,
courtroom. After the jury acquitted, or not acquitted, found Macias not liable, the line deputy. I mean, he's in his 20s. He's a young dad, from the Valley originally, and he felt terribly about what happened.
mm,
Even if he wasn't legally liable, he tried to help Jackson after everyone else left the cell. He said, and I don't have any reason to think he was lying, that he believed Jackson was calmed down, and then he said that, he filled in the phantom cell checks at the beginning of his shift, and that's what he always did, and they never told him not to. And that could have been the truth. That was up for the jury to decide whether that was credible. And I told them that if they could find that credible. If they did, they probably should let him off. Sarah went up to him, and, after the verdict, and he said sorry, and she said that she forgave him, and they cried and they hugged, and,
wow.
it was really sweet to see that. It was really nice.
Yeah, that forgiveness is
Yeah.
talk about doing good for your client to be able to facilitate that
Yeah.
healing process. That
Yeah.
is amazing. So, Spencer, kind of coming up on the end here of our time, what kind of advice would you give to people that are looking into jail cases? I mean, I feel like we've covered quite a bit with respect to suicide cases, but it sounds like there are all kinds of other types of cases that occur in the jail. What kind of advice would you give folks, and how much of a difference does it make if we're talking about private prisons? So that was a question that came up when you were speaking before about how you used to defend private prisons versus county government prisons.
Yeah. So one of the good things about jail and prisons is that basically everything is going to be recorded.
Okay.
So you should have a video of everything. If you're thinking even about looking at like seriously a jail or prison case, I would try to kick out a preservation letter ASAP, because different jails and different systems have different write over periods for video. And, people say a picture speaks 1,000 words. Well, video speaks, 1,000 more. So I, the, and unfortunately, the remedies for spoliation of evidence, in these cases, the standard is just so high. So you need to do everything I think you can to try to, preserve all the evidence and all the video. At least put people on notice that, hey, I'm sniffing around here.
Mm.
You know, I would, use Cora and CCJRA as much as you can. Get applications. for people's employment, find out what type of history they have, get all types of incident reports, anything that you can to kind of start piecing together what you can find. And then if you think you have some type of systemic problem, go look at the Board of County Commissioner minutes, because the board is the entity that typically is going to run the jail. And
Okay.
the sheriff actually runs it, but the county is the one that owns it. So they are the arbiters of what physical plant you use. And oftentimes, when you have a bad facility, when you start looking in those minutes, you're going to see the sheriff and the board bickering at one another over finances and money. And, you can kind of start to see the narrative and kind of create the history of what led up to kind of what happening and with in your particular case.
Wow, that
Uh,
is yeah. And what about the issue of the private versus government? Does that matter at all?
Yeah, it matters, especially in the sense of like if you're pursuing a 1983 case, private operators don't have qualified immunity, and
Okay.
unlike public entities, you can get punitive damages against private corporations under 1983. So another reason why pursuing claims against private entities can have some additional benefits to it. But they also the problem there is you don't have as much access to CCJRA or Cora or things like that to try to get records.
Okay. So but if I'm hearing that if a case comes in and it's a private prison, even though you might not be able to get the documents you need to screen the case, you still fire off spoliation letter, and depending on damages, etc., might be worth pursuing, even if you don't have everything you would hope to have. Does that sound about
Right.
right?
Yeah, yeah, and definitely, get in touch with the coroner. Find out what type of death investigation was done. Oftentimes, you can find some good information in there about the communication that was happening inside the facility. So,
So is it common for if you have prisoner on prisoner murder for there to be a potential claim for a lack of supervision?
potentially, those are really difficult cases. It's again, it's a situation where it's a deliberate indifference standard. So you have to show
Okay.
that the jail staff knew that this particular inmate was vulnerable for a
Hmm.
specific reason, and that this particular predator inmate was likely to be the one that would assault him. So,
Okay.
and the standard is very very difficult, and that's going to scare a lot of people off. But you also are allowed to rely on circumstantial evidence to prove the subjective knowledge component, and things like obviousness are an exception to that. So you don't have to prove subjective knowledge if you have evidence that whatever the risk was obvious. So there's that kind of avenue towards liability also.
Got it. Sean, what do you think? What kind of advice would you give to people on these types of 1980? Well, let me ask you: is this the first 1983 case that you have litigated deep and, of course, all the way through trial?
Yeah, yeah. First one to trial. I have litigated another one past some of the briefing, and then we settled. And I have a couple, I think now. Well, Spencer and I actually were working on another one. We just settled, so I don't remember how many I have, but I'm looking at another one that a buddy brought us on for down in Florida actually.
Hmm.
And it's something that is, it's like playing the game on hard mode. I mean, it's compared to like, your car crash, trucking, even premises liability case, it's substantially more difficult. It's up there with, and for different reasons, it's up there with product liability work I do, and but I like that, and I think it's sort of this high risk, high reward. So, my advice is from a business standpoint, set up your firm in a way that you can feel comfortable taking these kinds of risks because it just feels so good to actually do it, and to
Hmm.
do it the right way. If you are set up to do only this, I mean, good on you. Spencer pretty much does only this stuff. And, I don't have that level of fearlessness, but, but, it that can be done too. And, but I would like more people to take this kind of work. I mean, it seems really hard, but I think we tend to tell ourselves it's a lot harder than it actually is. And a lot of it is because we just don't necessarily know those first couple steps to take. I mean, you know, any criminal defense lawyer will tell you that they tell all their clients, be very careful what you say on any phone call, because every single call coming out of a jail or prison is recorded. Well, guess who else's calls are in that rule? All the calls of the deputies or the corrections officers. They're all recorded too. Throw that in your preservation letter. It's a tiny little thing, and it adds up. And people who do this work tend to be swamped with cases and can't take them all, and turn down a lot more than just the valid cases. Part of that is a problem of the law, and I think I hope the judiciary is a little, maybe if there are any judges listening, try to be maybe a little more generous with the fee multiplier so that we get more people taking these valid cases. But I think anyone like Spencer is more than willing to talk you through the facts, the law. Give him a ring, he'll talk to you, and he'll share preservation letters and core requests too. So, sorry, Spencer, I'm volunteering you for this, Spencer. But
no, I'm about to make it. I'm about to even up the ante, because Spencer, how do people get a hold of you if they want to talk to you and got questions about cases?
Oh, I mean, we're all over the internet, so it's easy to find us. It should be.
All right, easy. I mean, it is funny. I always listen to podcasts. People are always like, "How do you get in touch with people?" And it's sort of like, "Well, the internet, silly." I mean, it's not. It's like I'm like Deion Sanders. Like, I ain't hard to find. Sean saying.
Right. I mean, I don't have Deion's cell phone number, so
yeah. But you could find him if you needed to find him, Sean. Now you could give out your cell phone number right now, or Dormer Harpering, not hard to find.
Thanks, Steve.
And you both are going to be flooded with 1983 inquiries about these. It seems similar to Med Mal in a way, in that there's a lot of questions and cases, and very difficult. Is that? I mean, does that ring true to you guys?
Yeah, I mean, different set of challenges, but it feels same level of very, very difficult. And yet, righteous and important to do it.
Mm-hmm. Right. Well, kind of coming to the end of our time here, I just want to thank you both so much.
Yeah.
And it feels weird to say congratulations given the circumstances of the case, but you definitely prevailed and obtained justice for your client here. I mean, what happened is just so awful. So definitely congratulations. And thank you so much for coming on the show and imparting your wisdom, both to myself and all of our listeners. So thank you both for coming on, and hope to see you all next time on the Colorado Trial Lawyer Connection podcast.
Can I say one more thing, Keith?
Yeah, absolute. Please. Yes, so, I'm begging you.
We would be remiss if we didn't talk about this, the issue of suicide in general. I just want anyone to know that, the data shows that the vast, vast majority of people who attempt suicide once don't ultimately die by suicide. And that's because people care, and because life gets better, and because if you can live through this one, it does get better. And you will see, if you just ask for help, how many people give a shit and really, really, really do, and really love you. And, so if anyone's having that kind of thought, and this happens to have come up, I just want that person in particular to know that, part of why we do this is because we care about them. If we could go back and change what happened to Jackson, we would in a heartbeat, and we'd do it for anyone else, and we do this for everyone else who goes through the same thing, because we care about you, and I know that you guys feel the same way, and I hope that anyone listening who's dealing with that or has a family member who's dealing with that knows that.
Well, thanks, Sean, for I think just really making it clear why we do what we do, and why you too, did what you did in that arena, going to battle for Jackson and his mom. So thank you both for your amazing work on this case. And thank you, everyone, for listening, and we'll see you next time. Thanks, everybody.
Thanks.
Thank you for joining us. We hope you've gained valuable insights and inspiration from today's courtroom warriors. And thank you for being in the arena. Make sure to subscribe and join us next time as we continue to dissect real cases and learn from Colorado's top trial lawyers. Our mission is to empower our legal community, helping us to become better trial lawyers to effectively represent our clients. Keep your connection to Colorado's best trial lawyers alive at www.thectlc.com.